several of those representatives told us, and I'm talking about me, as well as one of the county commissioners, our county manager, and they informed us that they had decided to take this brand of action to make sure that their cases were properly prosecuted. They did it because they thought that our system was simply too slow.
Are they right?
I believe that the system is too slow. I believe that our current Fulton County criminal justice system is in great need of overhaul. My office, along with some other offices in the county, we're going to be making a recommendation to the legislature this year to see whether or not we can change that.
Is this a creative solution to a problem, or is it making the problem worse?
Well, I think it depends upon the defendant. If it is a first offender, someone who is not previously involved with our system, I don't think there's anything wrong with a police department and a police officer using some discretion to determine whether or not this person should be charged with a felony or whether or not it should be some lesser charge. If that is done with the purpose of rehabilitation.
How can we track something that isn't being measured if these charges are disorderly conduct, when in reality some of these people had scales, some of these people had guns, and they also had Schedule I, Schedule II narcotics, possession of a firearm and the commission of a felony, and yet instead they get a misdemeanor charge that doesn't even go on their record?
Well, I think that there's some real dangers involved in doing this. Due process demands that everyone in this judicial circuit who is faced with the same criminal circumstance, those defendants ought to be treated in the same fashion.
Someone arrested in the city of Atlanta is almost always charged with this felony possession charge. And yet, if they're in the northern suburbs, they get a break to a degree.
That's correct. If that person is arrested in East Point or the city of Atlanta, if they're treated in a certain way, that should be the same treatment they should receive in any other part of the county. If the charge is treated as a disorderly conduct, a municipal offense and not a state offense, then that means law enforcement, prosecutors are not advised that this person has in fact violated a probation, has now committed another charge, and is now a state repeat offender. And when you are not charging them with the appropriate felony, that's one of the dangers that I see.
Police officers identified these two guys as members of a gang. They had arrested them before.
Right. If the charge by ticket or charging them with a municipal offense is done for rehabilitative reasons, then I do not see a problem with the police department or the policeman using his or her discretion to do that. But once you get beyond that threshold, then you begin to run into problems. If you are a gang member, someone who has already been identified as a gang member, someone who has been arrested, then I don't think that this would be the appropriate circumstance to just say, we're merely going to give you a ticket. Because of the location of the offense being in this municipality, if the same thing occurs in the other part of the county, then you would expect that that person would be arrested.
If I'm an employer and I'm hiring someone and I just see disorderly conduct, I think fine. But if they were in possession of a firearm and a Schedule II narcotic and they were, there's no way for me to know that.
Well, let me tell you, and that's also not what our legislators planned. That's not what they intended. What they were intending to do with drug charges handled by municipalities is to give them the authority to handle low or small amounts of marijuana. They did not intend to give them the authority to handle cocaine and other dangerous drug cases.
Some of these guys were awaiting prosecution by your office. Some of them were on probation for prosecutions from your office when they were arrested in Sandy Springs. But it's as though those things happened on two different planets because the cases weren't reported. It didn't affect their pending case or violate their probation. Is that a problem?
That's really a problem because it also gives us an opportunity to use that information in any subsequent trial or any subsequent proceeding against that defendant.
These are good cops. but it's policy they're supposed to do this. And you've got an officer saying, don't worry, gang member, this cocaine charge won't be on your record. Is that telling people who are drug dealers, come on to Sandy Springs because the charge is going to be lesser?
Maybe this is the municipality that you should show up in, as opposed to avoiding that municipality, which I think is the purpose that they had set out, that they would somehow prevent crime. When you hear the officer and he says, well, this is not going to appear on your record, it would have been appropriate if that officer said, if you completed some meaningful activity. For instance, if you completed community service, or if that person was not, hadn't completed high school, if that person was required to complete high school, get a GED, or get a job, then if that officer said, hey, and if you do that, it won't appear on your record, I don't think that anybody would have any argument with it. But clearly, that was not the purpose of the arrangement.
These cases, the irony of ironies is that one of the reasons we were able to get all these records in this video is all of these cases have been adjudicated and within a few months, versus it can take a year or more before you come before a judge in Fulton County, right?
That's correct. There is a lot of misinformation about what goes on here at the Fulton County Superior Courthouse. I believe the system is too slow. It needs to get a lot faster. But I think some of the things that I hear is that, well, we need to do this because that case might not get prosecuted when it reaches the Superior Court. Well, that's just not true, because our statistics show that 98% of the cases that are sent to my office by municipalities in this county, 98% of them are prosecuted. Fulton County sends more cases to our state system than any of the other jurisdictions. In fact, in some of the categories, like aggravated assault, we're sending twice as many. I've heard from the policemen, they'll say, well, the sentences that the judges hand out, that those sentences are somehow much more lenient than the other surrounding areas. Again, that's not what the data indicates. In many instances, the Fulton County sentences are higher. Some of the officers believed that maybe their cases were not being prosecuted. Well, our data shows that we are declining only 2% of the cases that are presented to this office by municipal police departments, and that we are in fact indicting, or in the process of indicting, 98% of those cases. Many of the things that officers might believe about what goes on in our county, simply they are not borne out by the facts. One of the problems that I recognize as a problem with the county's system is that system is too slow. The system has to change, and that will be the nature of the recommendation that we're going to be making to our legislators, is that we have to change our system so that it is speedy enough that the people in Sandy Springs and the other areas in our municipality can see some results within a reasonable amount of time. And I think they've certainly got a good argument now that they are not seeing that result within a reasonable time because of the way that our system is currently constructed.